A very good afternoon to all of you. So, today we are going to discuss the landmark international tax case of Tiger Global International Holdings, which has been pronounced in January 26 by the Supreme Court of India. This judgment it addresses critical issues in international taxation, treaty benefits, and anti-avoidance measures. So, we are going to discuss the facts, key arguments, judicial journeys, and implications in more detail. Let us look at the Tiger global structure. So, at the core is Tiger Global Management LLC, which is a US based ultimate parent entity controlled by Mr. Charles P. Coleman, who serves as the beneficial owner and sole director. This US entity oversees a web of intermediaries in the Cayman Islands and Mauritius. It is designed to route investments into India. The seller entities, which is Tiger Global International 2, 3, and 4 holdings, are Mauritius-based holdings companies, each possessing tax residency certificates from the Mauritian Revenue Authority. These entities acquired shares in Flipkart Private Limited, a Singapore-based company, between October 11 and April 2015. Now, Flipkart Singapore derives its substantial value from underlying Indian operating companies, making this an indirect transfer of Indian assets. On August 18, 2018, these Mauritius entities sold the Flipkart shares to Fit Holding Sal, a Luxembourg entity linked to Walmart Inc. for a gross consideration exceeding $2 billion. Tiger Global claimed tax exemption under the grandfathering clause of Article 13 in the India-Mauritius DTA, arguing pre-2017 investments were protected from source-based taxation in India. However, the evidence showed real control resided in the US. Financial authority for transactions over $250,000 was vested solely with Mr. Coleman, while Mauritian directors were merely rubber stamped. They were making merely rubber stamped decisions. Board meetings and audited accounts in Mauritius were cited as operational substance, but the court deemed the entities as conduits for tax avoidance, lacking independent commercial purpose. Now, let us look at a few timelines and essentially the journey of this case. So, it all began in June 2011 with the incorporation of the entities. Now, between October 2011 and April 2015, the acquisition of Flipkart Singapore shares took place. On 2nd August 2018, an application was filed for a nil withholding certificate. On 17th August 2018, the withholding certificate was issued but denying the TTA benefits. The sale of shares occurred on 18th August 2018. And finally, in February 2019, an application was filed before the authority for advance ruling. Now, in March 2020, the AAR rejected the application on the grounds that it was prima facie a tax avoidance arrangement. The AAR did not go into the merits of the case. Then, after this, in September 2020, so after 9 months, a writ petition was filed with the Delhi High Court by the taxpayer. The writ was disposed of in August 2024 in favor of the taxpayer. Then in January 2025, the tax authorities filed a special leave petition in the Supreme Court. The matter was heard in March 2025 with the judgment reserved, and the order was pronounced by the Supreme Court in January 2026. Now, let us look at what was held at each and every stage briefly. So now, during the proceedings before the AAR finally rejected the application on the ground of it being a prima facie tax avoidance arrangement. So it said that the DTA benefits were not available on sale of shares of non-Indian company. This structure indicated the prime objective was only to obtain DTA benefits. So the taxpayer filed a writ petition before the High Court of Delhi, in which the judgment was in favor of the taxpayer. The High Court quashed the AAR ruling upholding Circular 682 and 789. Then, aggrieved by the order of the High Court, the revenue filed an appeal uh, before the Supreme Court of India. Now, let us discuss the arguments by the revenue as well as the taxpayer. So, the revenue's arguments before the Supreme Court were multifold. So, firstly, on the TRC, it said that it is not conclusive but only prima facie evidence of residence, and it cannot override the principle of substance over form. It does not preclude inquiry into actual control, treaty abuse, or transaction substance. Indian authorities can examine residency under Mauritius law. Second, on indirect transfer, this transaction qualifies as an indirect transfer under Article 13(4) with no grandfathering or limitation of benefits available. In cases of treaty abuse, domestic law applies. Thirdly, circular number 789, it is intended only for FIIs and mutual funds, providing policy certainty in that context, but not applicable to indirect transfers or business investments, and cannot override GAAR, which is the general anti-avoidance rules. Then on the GAAR, it said that it is a supervening anti-abuse code that overrides DTA with exclusions limited to specific FIIs or small value arrangements and fully applicable to indirect transfers. There were certain further arguments as well of the revenue. So regarding the GAAR, grandfathering is available to genuine investments made before 1st April 2017. However, Rule 10U distinguishes between arrangement and investment, meaning abusive arrangements remain subject to GAAR even if the investment predates 2017. The Supreme Court's decision in Azadi Bachao is distinguishable as it pertains to the legality of FII and mutual fund investments without involving indirect transfers. Similarly, the Vodafone decision is also distinguishable but affirms doctrines like substance over form, piercing the corporate veil, lack of commercial substance, and identification of sham or conduit entities. So these were the arguments of the revenue. Now coming to the arguments of the taxpayer at the Supreme Court, before the Supreme Court. So firstly, the taxpayer argued that the transaction was commercially driven and lawful, consistent with structures used by other FIIs and investment funds. Secondly, it said that on the treaty residency, Article 4 in the DTAA is a mandatory self-contained rule. Residency is determined solely by Mauritian authorities under Mauritius law, and India must accept it if the entity is liable to tax there. Then on the TRC, it argued that India cannot reinterpret Mauritian law to deny residency if a valid TRC exists. Section 94 and 5 and Circular 789 established TRC as exhaustive proof for DTA benefits. Then it further went on to argue, saying that DTA is a complete code. Treaty abuse must be addressed via treaty text, not by superimposing the domestic GAAR or substance rules, absent any express language. Then there were certain other arguments as well of the taxpayer on the Azadi Bachao and the Vodafone ruling. It said that the Azadi Bachao upholds Circular 789, which remains in force. Vodafone reaffirms the Look Act principle, disregarding structures only if they are artificial or colorable devices, which is not alleged here. Further treaty abuse concerns were addressed by the 2016 protocol, effective from 1st April 2017. Now, the core issue for consideration before the Supreme Court was whether the AAR was right in rejecting the application for advance ruling on maintainability grounds, treating the capital gains from the sale of shares in a Singapore company, which is holding Indian company shares, by a Mauritian entity controlled by an American company, as prima facie a tax avoidance arrangement, and thus whether it can be inquired into to determine taxability under the Income Tax Act read with the Mauritius Treaty. Now, coming to the findings of the Supreme Court. So the Supreme Court noted that the principal purpose test or the sole intent test distinguishes between permissible tax planning and impermissible tax avoidance. Tax planning involves planning within the parameters of the law, whereas tax avoidance encompasses mechanisms found to be illegal or sham. The court ruled that the structure was a preordained transaction which was designed for tax avoidance. The finding was that the entities were deemed conduit entities with no independent commercial purpose other than escaping taxation in both India and Mauritius. As quoted in the judgment, the real intention behind their incorporation and the obtaining of TRCs was to avail treaty benefits. The Supreme Court further noted that AAR, the Authority for Advance Ruling, is statutorily empowered to reject applications at the threshold where the transaction appears prima facie tax avoidant. It is sufficient if the AAR, on an initial examination of the documents, is satisfied that the transaction is for avoidance of tax. So words prima facie means at first sight, at first view, or based on first impression. The level of satisfaction required to arrive at a prima facie conclusion is much less as compared to when facts have to be proved. Now, invoking Chapter 10A of the General Anti-Avoidance Rules, which is Chapter 10A of the Indian Income Tax Act, it said that GAAR shifted the burden of proof. Under Section 96(2), the onus is on the taxpayer to disprove the presumption of tax avoidance. So Tiger Global failed to rebut this presumption, as they could not provide evidence of genuine commercial substance independent of the tax benefit. The ruling states that the transaction constitutes an impermissible avoidance arrangement. This application of GAAR reinforces the need for taxpayers to demonstrate substantive intent beyond tax savings. So finally, the Supreme Court held that this transfer was taxable in India. Now, coming to the key takeaways, especially for international tax planning purposes. So first and foremost, the real intention of the transaction is important, and impermissible tax avoidance arrangements will not be allowed. A tax residency certificate is necessary but not sufficient. So it does not prevent judicial scrutiny of beneficial ownership. Then a holistic approach must be followed. The courts will not view a sale in isolation, but will examine the entire transaction starting from acquisition to sale to detect any pre-arranged schemes. Then there's also a liability test, which is essentially treaty protection under Article 13 is available only if the assessee is actually liable to tax in the residence jurisdiction, such as Mauritius. So this judgment, it signals the end of treaty shopping and urges investors to ensure genuine substance in their structures. The investors must move beyond check the box compliance to demonstrating head and brain presence in treaty jurisdictions. I hope this video was informative, and do reach out for any further discussion on this. Thank you so much.